There have been a number of recent changes, changes to the F1 visa, the recent Hyundai raid that I know a lot of our corporate clients have questions about, the gold card. But I think we'll probably spend most of the time talking about the H-1B, both the $100,000 fee as well as the wage level weighting that's going to happen in next year's lottery. So I think it's important to start by just having some perspective that there's a lot of things changing right now, and the actual implementation is not going to be known for probably at least a month or two on some of these changes, sometimes even longer. Um, I appreciate and understand and sympathize with the fact that everybody wants to have their questions answered today, but unfortunately, we're living in a time where it's just going to require a bit of time and patience before we really know how the government is going to implement some of their changes. Okay, so just to start, if you missed the news, there was a raid a few weeks ago at a electric vehicle battery facility that was being built in Georgia. They arrested close to 500 people. Many of them were South Koreans, and of those, it sounds like most of them were here as business visitors. Um, Really the big takeaway for the people that are here, especially from the HR and legal side, is that you need to make sure that you're looking after contractors that are at your facility. You have some responsibility to make sure that your contracting companies are not utilizing people that are unlawfully or don't have work authorization. And then you need to think about how to have some processes in place to manage business visitors. I can get into a little bit more specifics later, but I just wanted to introduce this topic. Um, Now is not the time to be pushing boundaries of what someone can do as a business visitor. There's as much chance of somebody being stopped at the border as there is of a large scale raid that we saw. So I'm sure you don't want any of your people thrown into detention. They were treated very, very badly, and it's very difficult to resolve those situations quickly. Um, Moving on, Arthur, you want to talk a little bit about this?
Sure, sure. Hi, everybody. Thanks for being here. Just a quick update on this. Basically, for more than 30 years, certain individuals in either F or J status have been admitted to the U.S. for a period known as duration of status, rather than a specific date. Basically, this means that an F or J individual could stay in the US for as long as they have a valid I-20 or DS 2019, and as long as it takes for them to complete their activity, such as a program of study or a research period. Basically, according to this new proposed rule, F or and J non-immigrants would no longer be admitted for an indefinite, what's called duration of status. Instead, they would receive admission until their program end date, and which is capped for this proposed rule at 4 years, plus a 30-day grace period, which is now 60-day grace period. So that's a big change. This means that anyone needing additional time, either to finish their studies or transfer or pursue OPT, would need to file what's called an extension of status, which is the form I-539 with USCIS before their authorized day expires. So again, this is a proposed rule. The comments closed yesterday, September 29. And so still we'll need to see the comments the review based on the comments. So it's a pretty big change that everybody should be aware of. And again, still not it's still proposed rule, and we'll have more information in the next few weeks.
Okay, next, moving on to the gold card. I'm saving the best for last, by the way. The H-1Bs will be at the end. The gold card was an executive order. There had been a lot of speculation since Trump was elected about introducing something like this. One interesting aspect is that sorry, my computer decided it wanted to update all of a sudden. One interesting aspect is that initially there was talk of it being $5 million. So the fact that it's been reduced to $1 million, some people are viewing it as a sign that there's not as much demand for this program as one might think. Um, the reality is that it's a gift, it's a donation, so you would not see that money again. I think that will discourage all but the most wealthy people. But I was talking to some clients today that think that very, very high level positions at large tech companies, those companies might actually be willing to either give or loan this amount of money to make sure that their people can have the flexibility of having a green card. Um, it's yet to be seen. This is an executive order that the government agencies have 90 days to publish proposed rules. So it's not in place yet. The other thing that we don't know is that it seems like it's going to be folded into the EB1A extraordinary ability and EB2 national interest waiver green card categories, which have a quota already. So it's unclear how that will impact people that are already in those quotas. Will the people that make the donation jump ahead of them? Will it just be seen as one of the criteria? There are many questions on this one. We just don't really know yet. And finally, on H-1Bs, there's two things that happened within the past 10 days. Um, One was the presidential proclamation introducing the $100,000 fee. It caused a lot of anxiety, confusion, stress amongst everybody, not just the people with H-1Bs, but also their company representatives, their immigration lawyers. So please have some patience and understanding that the reality is there's still a lot of unknowns about this. The original language suggested that um, everybody would be subject to it as of September 21st, but there were some further statements that came out that seem to imply, I think there's still a bit of a wait and see that if you have your H-1B petition that's already been filed before September 21st, then you're not going to be subject to the $100,000 fee. Um, the Department of State has also confirmed that. So if you filed your H-1B this year before September 21st and it's approved, you should be able to obtain a visa abroad from the US consulate. Truthfully, we're recommending that people wait at least a month or two to let someone else be the test case. You don't want to be the one finding out if you're going to be subject to that fee. Um, if you're doing a H-1B change of employer, I know that we filed one on September 22nd. It's still pending. As far as I know, none of the immigration lawyers that I've been in contact with have gotten an approval yet. So there's I think the general prevailing thought is that change of employer petitions will not be subject to the $100,000 fee, but we probably have to give it another week or two to make sure that's actually the case. Um, what does seem like they should be subject are people that are filing first-time H-1Bs for cap exempt employers. So that those would be primarily academic institutions. A lot of academically affiliated medical centers would also be part of this. They're not subject to the annual cap. That's why they're called cap exempt employers. The language of the proclamation makes it seem like they would be subject, but again, so far I have not heard any reports of anyone receiving a $100,000 bill from the US government. There's not even information on the government website about how you would pay that fee. So I think they are genuinely only intending to enforce the new fee starting in 2026 after the next lottery. One other thing to mention about this is that there is a carve out for national interest exemptions that could apply at the individual level, at the company level, or at an industry level. So the government also gave themselves a lot of flexibility to say, for example, all healthcare professionals are not subject to the fee. That could be something that happens. Or they could say, we really like Amazon and we're not going to subject their employees to this fee. We don't know what the criteria are to qualify for one of these exemptions. Nothing has been published yet. Um, it almost seems like the government just wanted a lot of attention. There are very influential people in administration that want to get rid of the H-1B completely. So this could just be a way of sending a signal to the public that it's not going to be very easy to get an H-1B going forward. It wasn't that easy anyway, but the point is that this is not really impacting anyone yet. It is also very likely going to be litigated. So I think this is one where we really just have to give it a little bit of time before we know whether the fee will stay, whether it will be reduced to a different number, etc. And finally, a couple days after the $100,000 announcement, they announced a proposed rule, or they published a proposed rule to change the H-1B lottery selection process. So instead of being purely random, it's now going to be based on the offered wage. What that means is that, especially for the HR people who have gone through the H-1B lottery before, it means that it's going to require more work before putting people into the lottery because you're going to have to know very clearly where the person's going to work, what occupation they're going to be working in, and what your offered wage is. Um, in some cases, the wages will likely make the person too expensive to put into the H-1B lottery. I think what they've done is there are four wage levels, and the higher the wage level, the more entries that you get in the lottery. So, for example, a software engineer in the San Francisco Bay Area, a level four wage is around $250,000 a year. Um, it's probably going to be out of reach for a lot of companies to sponsor new graduates. So it's unfortunate news for the people that are attending that are on student visas. Your chances of being selected in the lottery as a recent hire from university are probably going to be very, very low. Um, the bottom line is, as I just said, entry level positions will have very little chance of selection. I think if you're a student, you're probably going to want to make sure you're applying at a company that has probably is big enough to afford your the level three or level four wage, unless you already have a lot of experience, in which case a smaller company may be willing to pay that. And now for the time you've all been waiting for, the Q&A. So please go ahead, and if you feel free to ask questions. I'm sure somebody will always be first. Nobody yet?
Hi, Ron. I have a quick question. This is Danny. Thanks so much for all the information. I'm wondering if you could just clarify, and I think this would be helpful for everyone in HR, for OPT, for individuals who are currently on an OPT, should we expect that the company would have to pay essentially 100K per chance to get in the lottery? Or just to
Yeah.
clarify, yeah.
Yeah. No, that's a great question. So um, The 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 simple answer is yes. So in addition to having to pay the level three or level four wage, the $100,000 fee is intended to come into effect for next year's lottery. So if somebody's currently on OPT and you're planning to put them in next year's lottery, that fee would apply. However, there's some thought that the $100,000 fee would only apply if the person is outside the US at the time of the lottery, which would mean that somebody who's in the US on a student visa with OPT, they might be exempt. And it's one of the areas that the government has not been clear enough about. I think we're just going to have to wait and see if they provide additional guidance on that.
Well, thank you so much. It's
Mhm,
helpful.
mhm.
I have a question, actually. Thank you for the presentation. So I'm not trying to, find loopholes, but
Yeah.
if we've got a lot of OPTs who are PhD candidates who have a lot of published work. So maybe they can bypass the H1 and go to the O1. And so there's not yet a fee for an O1, not $100,000.
Yeah.
So is that also an option?
Yeah, I mean, that's not only an option, I would encourage it. I mean,
Okay, good.
partly because, and I didn't pay you to say that, but our firm does
Right.
our firm does a lot of O1 visas. Um,
Right.
so I think for someone that you just described, an O1, I think companies have hesitated in the past because they're just not as familiar with the O1 or their law firm that they work with may not be as familiar. But I think going forward, it's probably going to become the first choice rather than the backup
Mm.
choice. And yes, you're right. The filing fees are, you still effectively you have to pay the premium processing fee, which is
Mhm.
almost $3,000. Um, what else was I going to say? But there's no prevailing wage requirement. So especially, for example, somebody at a startup company, a lot of their compensation is based on their equity, which can be helpful. Um, yeah, so the O1 would be a very good choice for a lot of people.
Wonderful. Thank you.
I think one of our concerns is that there were also people that were going directly to the green card, especially the EB1 and NIW pathways. Um, if the gold card impacts that in terms of the numbers that are available, um, it might become tougher it's already hard to get those approved, but it might become even harder.
Hi Ron, thank you for sharing all the information. I have a question regarding to the status change.
Mhm.
For example, if I'm already holding an H-1B and then later I change to B visa or F visa and then like changing back to H-1B, will I be subjected to these like 100K fee?
Yeah, I mean, it's another question that I don't think we have a clear answer to. That and also H4 spouses, um, what happens to them? Are they subject to the fee? All the signals would indicate that you would not be subject to the fee so long as you previously held an H-1B prior to September 21st, 2025. So that even if you switched, like you said, to B2 or maybe F1, and then you wanted to switch back later to H1B, as far as we can tell, you would not be subject to that fee. That's a good
Okay.
question. Great question so far.
Hey Ron,
Yes.
this is Simi. Thanks for the session. My question was regarding the grace period for H-1B candidates. Like, suppose something happens with a job, does this anyway affect like the grace period? Do you have information on that?
Yeah, great question. I didn't talk about that. It's not related to the items that we discussed, but um, what Simi is referring to is that a few years ago they introduced a 60-day grace period so that if somebody on an H-1B or another work authorized status loses their job, they would have 60 days to find a new employer. And if you read the regulation carefully, it talks about it as a discretionary period. And until this year, it was basically a given that you would be granted that 60-day period. Unfortunately, we have heard reports. I mean, luckily, none of our own clients have had this happen, but we've heard some reports of people trying to take advantage of the 60-day grace period. And even though their new employer filed the H-1B petition within the 60 days, there were some very tragic stories of H-1B beneficiaries being issued notices to appear. Um, Meaning that they're being put into deportation proceedings. And what seems to have triggered it is that their previous employer submitted a withdrawal letter to USCIS, which they're obligated to do. And USCIS was effectively ignoring the 60-day period. So it's a long way to say that the 60-day period still exists, but it may not be a given. So if I, it's a really difficult thing to say. I think if your company is if you have any awareness that your company is considering any sort of layoffs, you probably want to have an open dialogue with your HR to try to extend your time there as much as possible so that you can begin your job search. But I wish I could give you more optimism about it, but I think it's one of many things that the administration is basically trying to make life as difficult as possible, especially for H-1B holders.
Yeah. Thanks, Ron.
Mhm. There's a couple questions in the chat. Let's see. We may have already covered some of them. Um, Arthur, do you want to maybe take let's see when
Sure. Sure. There's one here from Nicole, which I think would be helpful.
Mhm.
Um, is there any indication that it's unsafe for H-1B holders to leave the country? It seems you're exempt, but I'm wondering if you heard anything about people crossing into the country since the announcement.
We have people that already had H-1B visa stamps for sure. They have been let back in without issue. I think what I'm not as clear about are people who attended appointments for visas since September 21st. I don't know, Arthur, if you have any other updates on that.
Not that I'm aware of. No.
Yeah, this is I mean it's a good question. It's one of those things where I would say this is why if you're in the US now, we recommend sitting tight for another month or two just to let someone else take the chance. You're the I guess the best way to think about it is that um, the officers at the consulates, the officers at the border, they're under tremendous pressure to make sure that they follow all the rules and that they don't give any benefits to people that may not qualify. Um, what was I going to say? They're probably not getting much more guidance than the public is about how to implement this new $100,000 requirement. So it's best to, like I say, just try to give it some more time before you travel.
Sorry, could I just clarify? Are you specifically
Yeah.
referring to people with newer visas or just like anyone in H-1B status? Because I've had mine since last year and I'm just trying to figure out if it's a bad idea to travel
Yeah,
for
so
work.
so you're not going to be applying for a new visa stamp while you're traveling?
No,
Okay.
you're not.
Yeah. So I think, unless you, I mean, not to put you on the spot, but unless you have committed a crime or done something like that, you should be fine.
Okay, thank you so much.
Yeah, of course.
Hey Ron, sorry, my internet broke out a little when the first person was asking. So just to clarify, was that suggestion to just maybe wait out a little to travel for people selected this year and not yet approved? That'd be my case. Basically, the understanding is usually it came out October 1st, right? So like for me, I'm pending. I got the H-1B selection earlier this year, but was planning on December going back home and getting that stamp.
Yeah, I mean, I would say, I mean, first of all, hopefully they adjudicate it by then. I know with everything that's happening, it's unclear how long they're going to take unless you use premium processing. Um,
Mhm.
it might be something you want to discuss with your company about possibly upgrading to premium processing. Um, but if, assuming it's approved, I would expect that by December we have clearer guidance or clearer, examples of what's working. So you could always schedule your visa appointment, and if things change, you could cancel it or reschedule it later.
Right. Okay.
Hmm. Yeah, but obviously, at first I thought you were asking about traveling before it's approved, and that I would not recommend unless
Yeah,
you,
no.
yeah,
No, I mean the my employer sent out, it's also broad, but basically saying it seems like people who have appointments in the consulates and embassies can still proceed with that, but
yeah.
was just wondering if you had a different perspective.
No, I agree with that. I mean, and so far, I haven't heard of anyone being asked to pay the fee. And there have been a number of people who have attended appointments in the past 10 days. So, um, as far as we know, the consulates are still issuing new visa stamps so long as the petition was filed before September 21st. I think the next group that's slightly unclear are H-1B change of employers that were filed after September 21st. I think those should be okay. I don't see any reason why they won't be, but that's kind of the next group of you know lab rats, guinea pigs, whatever expression you want to use. I think everybody unfortunately is in this position of having to just test out what happens. And so whenever possible, I would just recommend you try to delay. But I think December we'll know more by then.
Okay, and the filing, I guess that's the language that everyone's been asking.
Yeah.
Filing would be what happens like in March, not the approval, right? That's different.
Yeah, I mean, unfortunately, maybe intentionally, who knows? They were very sloppy with the way they use their language. I know we have a number of law students that are attending today, and they were very imprecise with the terms that they used. Um, n- new New the way that they used it means something totally different to anybody who's been practicing immigration law. But
Mm.
it seems like what they intend are only the people who apply after next year's lottery.
Okay, thank you so much.
Mhm. Let's see. I think we did some of the questions. Um, Yeah, there's a question about sort of like for future updates. So I've mentioned a couple times we're waiting to hear either from our own clients or other people in the immigration community what's happening with their clients. One thing that I would recommend if you're not already signed up for our newsletter is to do that. We'll put the link in our chat, and we'll make sure to have an update in a few weeks to let everybody know kind of the latest news about whether anybody's having any difficulty traveling into the US. It's a great point. Um, Arthur, do you want to maybe address Andrea's question and give some basics about the O1?
Sure, of course. So just before that, there's also a question here about, do you know if the 60-day period for F1 visa holders has officially been amended to 30 days? The answer is no. It's just a proposed rule yet. So we'll probably know shortly. And as Ron mentioned, happy to keep you all updated on the newsletter. For the O1, the O1 is it's the extraordinary ability visa. So we have two categories for that visa category. So it's the O1A, which is the O1 the extraordinary ability in business, science, and sports. And we also have the O1B, which is the extraordinary ability in arts, motion picture, television. So good way to think about it is, if you're more in the creative realm, you should apply for the O1B. If you're more in the, let's say, scientific, business, sports field, you should apply for an O1A visa. The idea of this visa is that you're very seasoned in your field, that you have worked for different projects, productions, companies, and you have some relevance in your field of endeavor. The way to prove it, kind of, just to give a kind of 2-minute explanation on the O1A and 2 minute on the O1B. For the O1A, you have basically 8 different criteria that you need to meet at least 3. Basically, if you have any awards in your field or if you're a member of any association that requires outstanding achievement, if you have judged any sort of relevant work in your field, if you have press in any relevant outlets in your field, if you have conducted any sort of critical work for companies of distinguished reputation, if you have had a high salary in any of those companies before, if you're in the academic field, if you have wrote scholarly work, and if you have any sort of original contributions also of major significance in your field. So out of this 8 criteria, you need to have at least 3, and you also need this basically to show that you have an extraordinary track record, and you need to show that you have work available for you in the next 3 years in the US. So you need to show either one or more job offers from people that want to engage your services in the future. So kind of, quick summary for the O1A. For the O1B, if you're a creative or work in the creative industry, it's sort of similar. Instead of 8 criteria, we have 6. So just kind of run through those quickly. Number 1 is if you have a critical role on projects of distinguished reputation. Number 2 is if you have any press in your field of endeavor. Number 3 is if you have a critical role in companies of distinguished reputation. So very similar to number 1, but number 1 is more focused on specific productions and projects. Number 3 is more focused on company or on your role in a company as a whole. Number 4 is if you have a record of critical/commercial claim in your field. Number 5 is significant recognition from your peers. So basically, in this one, we draft several expert letters from people saying, articulating how relevant you are in your field. And also number six is high remuneration, either past or future high remuneration compared to your peers. It doesn't need to be necessarily US. For example, if you've worked in other countries, you can of course compare that data to the specific country that you were in the past. So similar to the O&A, you also need to show that you have future work in the US, that you have deal memos and work offers, offer basically job offers from other either entities or people who want to engage your services for the next 3 years. Good thing about the O1, just as a last point, is that it allows some flexibility. Most visas, you need to be tied to one single company. That's not the case for the O1. You can work for more than one employer. So yeah, just kind of a quick summary on the O1. Ron, not sure if you wanna add to that. You're muted.
I forgot. I'll leave it at that for now. We could do a future session on O1s, but definitely one to think about, particularly if you've done something that makes you stand out from your peers. Let's get back to H1B. There's a couple more questions. So if you haven't had your questions answered yet, please add them to the chat. We're getting close to the end of them, so happy to answer more. So one question is about if you have an H1B and your job title changes or your place of residence changes, what do you have to do? And so it kind of depends. Um, if your job duties themselves are changing, so it's not just a job title, but the role itself is changing, the company probably needs to file an amendment with the USCIS. Um, if it's a change of residence, I think the reason why this question is being asked, and this applies to a lot of H-1B holders, is where they're allowed to work from home, either part of the time or all of the time. Um, your home location needs to be disclosed. It's part of the rules related to notifying U.S. employees about H-1B holders. So if you're working from home, that new address, first of all, this applies to everybody who's not a U.S. citizen. Whenever you move, you must update the USCIS within 10 days of moving. I had a client earlier today who forgot about it. Please don't forget, when you move, you need to update the USCIS within 10 days of moving. But in the H-1B context, it's even more relevant because if your company said that you could work from home, the labor condition application, the LCA, it needs to be reposted before you can work at your new home. That's assuming that you're living in the same metropolitan area that you lived in before. If you're changing, let's say, from Dallas to Houston, it actually would require an amendment with the USCIS. So anytime that something like that happens, you really need to review it with your HR or your immigration team before making the move. It's a lot easier to try to manage it before the change happens. If you find out afterward, it can be quite time consuming and expensive to try to fix it. That's a great question. So people who don't have an H-1B yet, please remember that your H-1B is for a specific job, a specific company, and a specific location or set of locations. So you need to always remind your HR because they may not remember before you accept any changes. Please check to make sure whether anything has to be done with your H-1B. And then there's a question, let me try to maybe rephrase it a little bit, but a question about changing from OPT to L1. And just maybe some basics about the L1 first. So the L1 visa, it's another temporary work visa, and it's for intracompany transfers. And one of the main requirements is that the US company has to have a related company outside the US, and you had to have worked for them for at least 1 year within the last 3 years. I won't go into all the details, but one thing that I'm a little bit confused with on this question, I mean, feel free to give me more details either now or offline, but if you're on OPT, it suggests that you've broken the 3 year period of employment. And so if the 1 year is not within the past three, then you wouldn't even qualify for the L1. But let's say that you worked for a company in the UK for a year and then you came to the US to do a master's degree. If that year of experience is still within the past 3 years, then yes, you could switch to an L1. It's probably, I think, in today's world, a more favored visa category than either the student visa or the H-1B. But that's a very, I would say, individual analysis that we would need to do to to make sure that we give the right recommendation. So feel free to reach out to me afterward so we can talk more about it. Um, Arthur, do you want to take Andrea's question?
Sure. Sure. So Andrew's question, does the 60-day grace period also relate to recent grads on OPT? So yes. So whoever is on OPT now, they, after the end of their OPT, they will have a 60-day grace period to either change their status to a different, let's say a different visa category, or potentially leave the country.
And then next question is also OPT related. So if I'm understanding this right, the two job offers are related to working on the OPT. Um, would it be an issue to do two full-time jobs? I'm not an expert in what the universities are allowed to authorize, but I actually don't think they're allowed to authorize that. I don't know if anyone else on the call has more detail about it. There's sort of a question of whether you would actually be working 80 hours a week or not. I mean, obviously it's possible, but
Yeah, I'd say it would be risky for them to question you being basically overemployed and being genuine about working 80 hours a
yeah,
week.
I would be cautious about that because as Arthur mentions, it could potentially come up later when you apply to switch to H-1B or O-1, either with the USCIS or when you apply for a visa stamp. But unfortunately, I'm not aware of the specific rule about whether that would be permitted or not. It honestly, I would ask your university to see if they would be willing to authorize that. Let's see. What is a penalty for taking more than 10 days to notify USCIS about the change of residence? Would this impact a pending H-1B petition? Great question. The penalty is you are eligible to be removed or deported. Does that actually happen? Not that I have ever heard of, but it's one of those things where if they wanted to deport you for some other reason, they could use it to say that you didn't follow the rules. So if you haven't, if you've missed that 10-day window, I would say file the address change as quickly as you possibly can. Um, is something going to happen to you, though? Very, very unlikely. By the way, the purpose of that rule, or one of the main purposes of that rule, is that if somebody is ordered deported, they need to be able to find them. I'm not so sure that that's as much of a concern these days. The government seems to be finding people no matter where they go, but the original intent, I think, had more to do with if you didn't update your address, it gave the government one more reason to remove you from the country. Oh, let's see if we have the same answer to the follow-up question about the 60-day grace period, Arthur. I think they're very different things. The 60-day grace period for the work visas, That is just by the very language of it, it's discretionary. I believe the 60-day grace period for OPT is definitive. I don't know, Arthur, if you have a different opinion about it.
Yeah, yeah. I mean, if somebody finishes the program properly, it's definitive. But there are a couple of caveats. If for example, the school terminates the program or anything like that, or the person, if basically the person does not finish the degree, so it will be there are different layers, but usually it's definitive.
Yeah, I think practically speaking, somebody who's in their grace period, I strongly recommend that you carry documentation with you on your person. If you're stopped, you don't want to be trying to look for something on your phone. So have a copy of your I-20, your EAD card with you if you're on OPT. Um, if you're in that 60-day grace period, unless you already have, if you have another application that's about ready to be filed, maybe carry some sort of evidence that you're about to file um, an H-1B perhaps, or change to B2. If it's already filed, have a copy of the receipt notice. Um, or if you're just getting ready to leave the US and go back home, maybe have a copy of your travel itinerary. Let's see. I'm gonna come back I'll come back in a minute to the question about travel. Um, do you recommend premium processing? I mean, I'll try to answer this as clearly as I can. Um, Given everything that's happening right now, uh, unless you have some other work status, um, I would say you want to get the H-1B petition approved. But if you're somebody who applied for H-1B from F1 and your OPT is already expired and you were relying on the cap gap only took you through today anyway. So those people, you definitely should be upgrading to premium processing if your H-1B is still pending. I think if your OPT goes longer than today, or if you're on L1 or TN or E2, I don't know if we have any of those, and you're applying to change to H1B, I don't know that it's necessarily that urgent. However, I will say that USCIS seems to be moving slower than before for cases that are not premium processed. Um, you might want to wait and see what happens with the government shutdown that is probably going to happen today, unless there's been a headline while we've been talking. Um, that could impact processing further. USCIS generally does not shut down during the government shutdown, and that's because they're funded through application fees, not through tax dollars. Um, so I'm not really giving I know I said I would give as clear an answer as I can, and it's not clear. If you might even want to give it another month because I suspect that they will start making their way through the non-premium cap cases in the next few weeks. But if it's not approved by the end of October, you might want to it's hard for me to really recommend it because it's a lot of money, but it's probably a good thing to do for both the employee and the company just to have clarity on the status change. Let's see. I'll just come back to the question about travel for a moment. I know we talked about this at the beginning of the call, but just to recap, uh, if your H-1B was filed before September 21st, 2025, and your H-1B petition is approved, you should be able to travel and obtain a visa and be readmitted without having to pay the $100,000 fee. All of the guidance that's come out in the past 10 days points in that direction that the only people that will have to pay the fee will be people entering the lottery next year. But my advice is if you can wait a month or two, let someone else be the person to try that theory out, just because of the fact that the guidance is not perfectly clear from the government. I think there was a follow-up question from the same person. Uh, yeah, I think maybe rather than going into such a specific question here, maybe reach out to me afterward about that. I think my short answer is going to be the same as what I just said, though, which is it's you're probably going to be okay, but there's some uncertainty until we hear about more people being led into the country. But so far, all the reports are pretty positive. Um, Different type of question. Can you outline the key factors an employer should be aware of before hiring an OPT holder? That's a great question. I find that oftentimes companies hire people without realizing that the OPT or without really appreciating the fact that the OPT might be the end of the road for someone's ability to work in the US. Um, their most likely option traditionally has been to go into the H-1B lottery, but the lottery, the chances of being selected in the lottery this year were only around 35 to 40%, which was actually higher than the previous year. That's a bit of a gamble that you're taking on someone, particularly if their OPT has less than a year remaining on it. That means that they're only going to have one chance to go into the H-1B lottery. Um, with the proposed changes to the lottery system that would give people with higher salaries a greater chance of being selected, that might be a factor that you want to consider. Is this somebody that you're paying at a level 3 or level 4 wage? So that might be an analysis that companies should start taking before you even hire somebody on an OPT. Are you paying them at a wage level that's likely going to give them a greater chance in the lottery? Or think about applying for an O1 earlier rather than having it be the backup plan, but maybe apply for the O1 before the H-1B lottery for candidates who have those markers of being extraordinary in their field. Trying to think, any other tips you would give, Arthur, about what companies should think about when hiring somebody on OPT?
Probably just th knowing the difference between the regular standard OPT and STEM OPT, and just the OPT being a temporary employment authorization up to 12 months. If the beneficiary is has a STEM degree, might apply for a 24-month STEM extension. You need to know that they need to present an EAD card, employment authorization card issued by USCIS to be for the company to be able to hire that person. Um, it- Employers don't need to sponsor or file paperwork with USCIS for the OPT, unlike the H-1B, which makes things a little bit easier. Um, and let's see, an employment must be in the field of endeavor, related to the field of endeavor of that beneficiary. And in terms of, we talked about, part-time, full-time a couple questions ago, but for standard OPT, it's usually can be part-time, but it needs to be usually at least 20 hours a week or full-time, of course. And yeah, and then for STEM OPT. It needs to be at least 20 hours a week. And I believe no volunteer roles are allowed. And yeah, I think just some pointers for the OPT.
Let's see, there's a follow-up question. Let me just try to read this quickly. Yeah. One thing I would add to that, if your company has not previously hired somebody on STEM OPT, your company must be registered with E-Verify. Um, I know I recently had a company that thought it was going to be an easy undertaking, and once they realized that they were going to have to use E-Verify for every person they hire going forward, not just visa holders, they decided not to do it. Um, but it's something that you need to be aware of before you just uh, think that you've gotten lucky with somebody on STEM OPT. Let's see that the follow-up question is, do we have a recommendation for how HR should deliver this info to candidates? So Trying to put myself in the shoes of the recruiter, and you're under pressure to find a good person for a particular role. And you have a candidate who's very eager and tells you, "Oh, I have OPT, you don't have to do anything." I think perhaps one thing that you can say is something along the lines of, "We really see this as a long-term investment in you, and so we need to already be thinking about what happens after your OPT." I think I would maybe say something like that. In terms of whether you want to give preference to candidates that might qualify for O1, um, I don't know that you necessarily have to tell them that. I think you could just make sure to collect their resume, and then during the I guess the initial interview that the HR team does, or even later stages, ask them if just build into your standard list of interview questions something about, do you have any accomplishments that you want to tell me about, or anything impressive that you've done that's worth sharing? Something that might help you gauge whether it's somebody who could stand out from the crowd. I think that's really what we're looking for in an O1 candidate. Examples could be a paper that's been published, they spoke at a conference, patents that they were part of. Um, Maybe they had a prior startup company they founded. How successful was that? I think if you can try to gauge that, I think it'll help you at least distinguish between the OPT candidates. And by the way, for those of you who are going into OPT, those are also the sorts of things that you want to already be thinking about to build your profile, so that an employer might be more interested in hiring you to do the O1. Let's see, we're reaching the end of the time, so let's see. I think there might be one more question. Okay, so this is not a very happy question to end on, but if you have your H-1B approval and then you go to the consulate to get your H-1B visa stamp, and for some reason they deny you, what do you do then? Well, I think the first thing I would say is try to get as much information as you can before you leave the consulate, because once you've left, it's almost impossible to communicate with them. So you have the right to ask, is there a reason you're denying me? Did I not tell you something that you were looking for? Try to ask those questions. I know it can be nerve-wracking, and hopefully this doesn't happen to anyone, but try to ask those questions before you leave. And then the next thing to do is find a place where you can very quickly take as many notes as possible about everything that was said, and everything that they said to you and everything that you said to them. Those questions and answers can be extremely helpful in trying to rehabilitate the application. In most cases, you'll need to apply again. But that's really the only chance that you'll have. And then the question of would your work be terminated if that happens, that's really going to depend on the employer. Some employers might be willing to have you work from outside the US for a period of time. Um, I think a lot of employers probably would eventually, they might give you some time to try to apply again, but I think in some cases they probably would eventually terminate you. But that's really going to be an individual and company specific scenario. Not sure, Arthur, if you have any other last thoughts on that.
Yeah, I mean, there's no limitations on how many times you're able to apply. Of course, as Ron said, it's good for you to understand what went wrong the first time, so you can try at least to fix it and prepare your attorney to attend the second time, and yeah, and possibly overcome the consulate's concerns.
So on that, just really want to thank everybody for attending. Great questions. I think the questions covered a lot of topics that people wanted to hear about. So thank you for taking the time to be thoughtful about how you asked the questions, because I think it was helpful. Um, Please do, I don't know, Arthur, if you can put the link again, please sign up for our newsletter if you haven't already. That way we'll send an update in about a month just to let you know kind of the latest updates. We know it's a really tough time for everybody, so please hang in there. Um, uh, you know, I times will get better. I think that's the only way to think about it, and just persevere and keep working as hard as you can, and things will work out. Thanks, everybody.
Thanks, everybody. Hope you have a good week.